Thank you all. We're at the appointed hour. Thank you for joining us on this morning for this presentation. This presentation will be a first of a series of presentations, and this presentation will concentrate on legal, labor, and commercial and some related issues arising out of the acute respiratory syndrome, novel coronavirus 2, also known as COVID-19. The purpose of this presentation is not to discuss in detail each and every commercial and legal issue which has or may arise in light of the COVID-19 pandemic and the resultant legislation, but is rather to flag and concisely discuss some significant commercial and legal issues which have arisen in light of the recent outbreak of COVID-19. As you're all aware, pursuant to the World Health Organization categorizing COVID-19 as a pandemic, President Ramaphosa declared a state of national disaster in South Africa on the 15th of March 2020 in terms of the Disaster Management Act. On 15th of March 2020 in terms of the Disaster Management Act 2002, and on the 18th of March 2020, regulations in terms of Section 27.2 of the Disaster Management Act were published with immediate effect. And subsequently, on the 23rd of March 2020, President Ramaphosa announced a nationwide lockdown for 21 days, with effect from midnight on Thursday, 26 March 2020, and the latest lockdown regulations in terms of the Disaster Management Act were published on 25th of March 2020 with immediate effect. As a result of the lockdown, all South Africans were required to stay at home until midnight Thursday, the 16th of April 2020, and will only be allowed to leave their homes under strictly controlled circumstances, such as to seek medical help, buy food, medicine, and other supplies, or collect a social grant. During this time, all shops and businesses are required to close except for pharmacies, laboratories, banks, central financial and payment services, supermarkets, petrol stations, and healthcare providers. This brings us to our first important and probably most pressing legal consideration in the circumstances, that relating to employment. As a result of the government-imposed lockdown period of 21 days, employers are required to close their businesses unless they are exempted from such closure. As such, employees will be absent from the workplace, and if an employer is unable to work remotely, the employee will be required to utilize annual leave for the period of absence, subject to any collective agreement or sectoral determination to the contrary. This is pursuant to the provisions of Section 20, Sub 10, Sub B of the Basic Conditions of Employment Act 1997, which holds that in the absence of an agreement, the employer may require that annual leave be taken at a time determined by the employer. Also subject to any collective agreement or sectoral determination to the contrary, once annual leave or other leave entitlement that the employee is entitled to in terms of the BCA has been exhausted, the period of absence from the workplace as a result of a government-imposed lockdown would constitute unpaid leave, as the lockdown would amount to a force majeure or supervening impossibility of performance, which ultimately means that the employer and the employee are unable to fulfill their obligations in terms of the contract of employment, and the employer would then be entitled to implement the no work, no pay principles. An employer may also wish to consider whether to implement temporary layoffs or short time in the circumstances, as this will entitle the affected employees to seek assistance from the Unemployment Insurance Fund. However, I point out that in the absence of an applicable collective agreement, sectoral determination, or industry arrangements regulating the issue, the employer will not be entitled to implement temporary layoffs or short time without agreement with the affected employees, as this would constitute a unilateral suspension or variation of the employment contract, which is prohibited. Parties to some bargaining councils, like the Metal and Engineering Industry Bargaining Council, have concluded collective agreements which permit employers to lay off or initiate short-time measures where unforeseen circumstances halt production. In the absence of agreement with the affected employees, sectoral determination or collective agreements or industry arrangements it would be necessary for the employer to proceed under the umbrella of a retrenchment consultation process in terms of Section 189 or 189A of the Labour Relations Act of 1995. This, however, is a complex area of our law, and legal advice should be obtained before proceeding with these measures. Other forms of leave that are available to employees in terms of the BCA during this time would include sick leave and family responsibility leave. In the event that an employee contracts COVID-19, the employee would be entitled to take sick leave even during the period of national lockdown. The normal rules regarding sick leave would be applicable in the circumstances. Therefore, if an employee is sick for more than 2 consecutive days, the employee would be required to provide a medical certificate evidencing proof of incapacity for the duration of the employee's absence on account of sickness or injury. If an employee is tending to a sick family member, this would not constitute sick leave, but may constitute family responsibility leave if the employee's child is sick. Similarly, family responsibility leave is not applicable where the employee needs to care for a child who is not sick, but who as a result of school closures may be looked after. In such circumstances, the employee may need to take annual leave. Family responsibility leave is 3 days paid leave during every annual leave cycle, provided that the employee has been employed for more than 4 months and works at least 4 days a week for that employer. As regards sick leave, an employee is entitled to an amount of paid sick leave equal to the number of days that the employee would normally work during a period of 6 weeks. However, during the first 6 months of employment, the employee is entitled to 1 day's paid sick leave for every 26 days worked. In the event that an employee contracts COVID-19 during the course and scope of their employment, the employee would be entitled to claim compensation in terms of the Compensation for Occupational Injuries and Diseases Act, 1993, from the Compensation Fund, without having to prove the employee's negligence, provided that the employee contracted COVID-19 after a single or multiple exposures to confirmed cases of COVID-19 in the workplace or after an official trip to a high-risk area. Whilst COIDA protects employers from delictual liability, if the employer was in fact negligent in not implementing reasonably practical measures to maintain a working environment that is safe and without risk in the workplace to the risk and health of its employees, the employee may receive increased compensation, and the cost of such increased compensation may be passed on to the employer in the form of increased assessment rates. Once the lockdown period has concluded and employees have returned to work, the provisions of the Occupational Health and Safety Act 1993 would be particularly important. In terms of Section 8, Sub 1 of OHSA, every employer is obliged to provide and maintain, as far as is reasonably practical, a working environment that is safe and without risk to the health of its employees. This would include, inter alia, firstly, taking steps as may be reasonably practical to eliminate or mitigate any hazard or potential hazard to the safety or health of employees. A hazard is defined as a source of or exposure to danger. Secondly, providing such information, instruction, training, supervision as may be necessary to ensure, as far as is reasonably practical, the health and safety at the workplace of its employees. And thirdly, enforcing such measures as may be necessary in the interests of health and safety. An employer is further prohibited from permitting a person to enter a workplace where the health and safety of such a person is at risk, and this is in terms of the general safety regulations published under OHSA. Within the context of COVID-19, there is a clear obligation on the employer to manage the risk of contamination in the workplace. Reasonable measures to ensure a healthy working environment in the circumstances would include ensuring that the workplace is clean and hygienic, promoting regular hand washing by employees, promoting good respiratory hygiene by employees, and keeping employees informed on developments relating to COVID-19. Employers may even refuse entry to the workplace to an employee who has been infected or is suspected of having been infected with COVID-19 in order to comply with their obligations in terms of OHSA and to ensure that other employees are not exposed to an unsafe work environment. On the 23rd of March 2020, when President Ramaphosa announced the national lockdown, one of the measures that was announced was that the government was in consultation on a proposal for special dispensation for employers that are in distress due to COVID-19. The intention is that through this proposal, employees will receive their wage payment through the Temporary Employment Relief Scheme, also known as TERS, which will enable employers to pay employees directly through this period and avoid retrenchment. In terms of the TERS process, the Unemployment Insurance Fund may fund distressed employers directly in relation to the TERS allowance. The distressed employer will only be funded if it meets the key requirements of the UIF, being the following. The distressed employer is able to demonstrate that it has been compliant with the relevant UIF legislation. If not compliant, the distressed employer undertakes to pay outstanding contributions and bring its obligations up to date within a stipulated time frame. The distressed employer is able to demonstrate that it will or has embarked upon a turnaround or sustainability program, which will result in job preservation at the expiry of the funding agreement, and the distressed employer will be able to meet its obligations in relation to the UIF legislation. The Central Adjudication Committee will then consider applications of applicants and issue one of the following. If the applications are for wage subsidy, a wage subsidy ruling will be directed to the UIF for processing. Where an employer requires over and above wage subsidy and training intervention, the Commission for Conciliation, Mediation and Arbitration will issue a ruling directed at the relevant sector, Education and Training Authority, SETA. And thirdly, where an employer requires turnaround solution intervention, the CCMA will issue a ruling to Productivity South Africa. To obtain application forms in respect of TERS and all relevant details, an applicant employer is required to send an email to covid19ters@labour.gov.za. The employer must thereafter send the completed application for TERS to the CCMA as directed. Within 5 days of receipt of complete, valid and accurate applications, which may be delayed due to the COVID-19 pandemic, the Central Adjudication Committee will consider the application and the employer will receive a letter with a ruling informing them of the success or rejection of the application. An employer with a successful application will be required to enter into a formal memorandum of agreement with the UIF. A draft MOA will be sent to the employer for comment and shall thereafter be subjected to legal scrutiny and vetting, after which a final MOA with all required supporting documents shall be signed by the employer and the UIF. Upon conclusion of the MOA, the first tranche of payments shall be made to the employer within 5 days, which may be delayed due to the COVID-19 pandemic. It is important to note that the TERS allowances are payable monthly to each participating employee and will not exceed 17,242,000 Rand for high income earners. A monitoring team shall be sent to the employer to ensure that the funds are utilized in line with the signed MOA and that no breach of MOA has occurred. The remaining payments shall be made in line with the signed MOA. Another important legal consideration is that relating to agreements and contracting parties. It goes without saying that that COVID-19 threatens the ability of contracting parties to meet their obligations or perform as required under the relevant agreement regulating their relationship, particularly in light of the nationwide lockdown. It is therefore vitally important that during this time, parties review their agreements and seek to limit the risk of non-performance or non-performance by a counterparty, and in so doing should consider some of the following factors. Breach. Businesses should assess which of their obligations are affected and whether this might result in a breach of the relevant agreement. The consequences of such breach must be considered and proactive steps must be taken to limit or correct such consequences. An easy example of a consequence that may follow a breach of an agreement is that the defaulting party might be liable for damages suffered by the other party. Another result of breaching a term of an agreement might be that a party may have the right to terminate the agreement, and such a breach may constitute an eventual breach which entitles the non-defaulting party to immediately cancel the agreement. As regards performance clauses, businesses should be aware of clauses with strict time constraints for certain actions, as any delay to comply with such time constraints may be material and may entitle the non-defaulting party to terminate the agreement failing timeous remedy. A breach of contract may be countered with several defenses, such as a force majeure or raising a supervening impossibility of performance. This brings us to the next consideration, and that is of partial performance, non-performance, or disruptions. And there are some common law principles which apply in these circumstances. The first being force majeure. A force majeure clause in an agreement typically excludes non-performance of contractual obligations when an extraordinary event or circumstance beyond the control of the parties prevents performance by one or both of the parties. Being excused from performance while the event continues should avoid being placed in breach and limits the exposure to damages being claimed for non-performance. Determining whether COVID-19 constitutes a force majeure will require careful consideration of the force majeure provisions relied upon, the contractual obligation in question, and the reasons for non-performance. Should a party wish to invoke a force majeure clause, it should confirm whether the clause requires it to give notice of force majeure, and if so, when notice must be given. One should be careful to meet the requirements for such notices as precisely as possible, including the address to which it must be sent and what level of detail or information the notice should contain. Further consideration is that of supervening impossibility of performance. This is a common law defense that suspends or in some cases terminates a party's obligations where an irresistible force or unforeseeable accident has made fulfillment of its contractual obligations impossible. The defense applies generally to all contracts and may be relied upon in the absence of a force majeure clause. In general, our courts have restricted the scope of this defense so that it applies in very limited circumstances. Given recent developments and principles applying to contractual interpretation, the standard as to what constitutes impossibility of performance may be impacted upon by public policy and equity considerations, heightened by the need for a careful consideration of all relevant factors when assessing this issue. In light of this, and if the alleged impossibility of performance is a consequence of COVID-19 and compliance with government directives and norms, such as social distancing or a lockdown, a court might find that public policy dictates that parties should be relieved of their obligations so that they can comply with these directives. In the event of a supervening impossibility of performance, the risk of being placed in breach and facing a possible damages claims whilst the event continues is mitigated. A further consideration is that of variation and waiver of obligations. Because as a consequence of COVID-19, parties that are unable to fulfill their contractual obligations in strict conformity with their agreement may ask the counterparty to accept incomplete or defective performance or to waive the obligation in its entirety. A party facing such requests should be careful to ensure that in granting an indulgence, that it is not inadvertently varying the contract or waiving its contractual rights. By contrast, a party seeking an indulgence should ensure that any variation or waiver is effective and binding on the counterparty. In both instances, we strongly suggest that any variation, waiver, or indulgence is properly reduced to writing in the form of an addendum to the agreement, which would then be executed by the parties. Further consideration is that of whether the contract contains material adverse change or material adverse effect provisions. In this regard, businesses should be alert as to whether any material adverse change or or material adverse effect provisions, which are commonly found in certain commercial agreements, are triggered as a result of the pandemic. Such clauses may permit a party to avoid or otherwise alter the terms of an agreement should the pandemic or its effects be categorized as a material adverse change or cause a material adverse effect. Having regard to the aforegoing, we suggest that businesses should review their existing agreements to identify any applicable force majeure clause and/or any material adverse change or material adverse effect provisions which may cover pandemics such as COVID-19, and the procedure that must be followed by a party seeking to invoke these provisions. It is also advisable for businesses to identify and consider any potential exposure to loss or damages resulting from partial performance, non-performance, or disruptions, which would include considering whether the applicable agreement contains a damages limitation clause or an exclusion of damages clause. A decision should then be made regarding the approach to any potential non-performance, partial performance, or disruptions, and whether to initiate the provisions in the agreement or to commence mitigation measures. It is important to note that a party suffering damages as a consequence of a breach, which is not excused by a force majeure clause or the common law defense of a supervening impossibility, is under an obligation to mitigate its losses. Following the declaration of a state of national disaster in South Africa on the 15th of March 2020, the government has implemented certain measures in an attempt to mitigate or lessen the effects of the pandemic on certain businesses. One of these measures is the implementation of regulations by the Department of Trade and Industry in respect of the retail property sector, which were published on the 24th of March 2020 and came into effect immediately. The purpose of the regulation is to exempt a category of agreements or practices between designated retail tenants and retail property landlords from the application of Section 4 and 5 of the Competition Act 1998 in response to the pandemic. The Minister, in terms of the regulations, has exempted the following category of agreement or practice among and between designated retail tenants and the retail property landlords, if undertaken at the request of or in coordination with the Department of Trade and Industry for the sole purpose of responding to the COVID-19 pandemic. Agreements with the sole purpose of ensuring the survival of tenants of retail properties during the COVID-19 national disaster, which are limited to agreements or practices in respect of payment holidays and or rental discounts for tenants. Secondly, limitations on evictions of tenants. And lastly, the suspension or adjustment to lease agreement clauses that restrict the designated retail tenants from undertaking reasonable measures required to protect viability during the national disaster. To qualify for an exemption, such agreements must extend to all South African retail tenants in such designated retail lines. The designated trading lines for the purposes of the identification of designated retail tenants are, firstly, clothing, footwear, and home textile retailers. Secondly, personal care services, and thirdly, restaurants. During this period of lockdown, the lockdown regulations which were published on the 25th of March 2020 will be applicable and will have drastic effects on business and individuals alike. The important considerations flowing from these lockdown regulations are as follows. For the period of the lockdown, every person is confined to their place of residence unless strictly for the purpose of performing an essential service, obtaining an essential good or service, collecting a social grant, or seeking emergency life-saving or chronic medical attention. Essential goods are defined as the goods referred to in paragraph A of Annexure B, as may be amended from time to time, and includes food, cleaning and hygiene products, medical products, fuel, including coal and gas, and basic goods, which includes airtime and electricity. Essential services means the services as defined in Section 213 of the Labour Relations Act 1995 and designated in terms of Section 71 sub 8 of the Labour Relations Act, and as detailed in paragraph B of Annexure B to the regulations as amended from time to time. It is important to note that this list differs from the essential services lists distributed by media earlier in the week, and for example does not include, firstly, essential back office staff services to enable salary and human resources departments to work so as to ensure smooth management of wage and salary payments, and secondly, key maintenance employees who are required at workplaces to avoid serious damage to economic assets where the interruption of that service will destroy critical working areas, factories, or machinery. It is uncertain whether this was done purposefully or whether it was done without intent. Movement between provinces is prohibited. Movement between metropolitan and district areas is prohibited. All businesses and other entities shall cease operations during the lockdown, save for any business or entity involved in the manufacturing, supply, or provision of an essential good or service. Retail shops and shopping malls are required to close, except where essential goods are sold, and on condition that the person in control of the said store must put in place controls to ensure that customers are kept at a distance of at least 1 square meter from each other, and that all directions in respect of the COVID-19 pandemic are strictly adhered to. Retail stores selling essential goods are prohibited from selling any other goods. All borders of South Africa are closed during this period of lockdown, except for the transportation of fuel and essential services. The head of an institution must determine essential services to be performed by his or her institution and must determine essential staff who will provide these services. The head of an institution may delegate this function, having regard to the complexity and size of the operation. Persons performing essential services in this regard must be duly designated in writing by the head of an institution on a form that corresponds substantially with Form 1 in Annexure C to the regulations. An institution is defined as any public or private institution that is engaged in the supply or distribution of an essential good or service. A head of an institution is defined as the accounting officer of a public institution and the chief executive officer or the equivalent of a private institution. All commuter transport services are prohibited except for bus services, e-hailing services, and private motor vehicles for the purposes of rendering essential services, obtaining essential goods, seeking medical attention, funeral services, and to receive payment grants subject to the condition that all directions in respect of COVID-19 pandemic are strictly adhered to. Where a person rendering an essential service is unable to travel to and from his or her place of employment, the employer must make the necessary transport arrangements subject to the condition that all directions in respect of the COVID-19 pandemic are strictly adhered to. A copy of the lockdown regulations are available on request. Thank you for your time and attention. Please join us for our next series of webinars, the first of which will be held on the 31st of March 2020, and which will address business continuity in the light of COVID-19. If you have any questions, please feel free to contact me, or if you require any advice or further discussion around these issues that we have discussed today, please feel free to contact me on my email, which is on the screen at the moment. Thank you very much.